Good afternoon to the webinar audience. I'm Marie Baker. I was a judge of the Irish Supreme Court until this time last year. I'm now the chair of the Electoral Commission of Ireland on Comisiún Tábháin. This is a 1-hour webinar. It's part of a series of events we've had with the first fully online event. And it's an overview of the European Commission's Rule of Law Report 2025. These reports have been done for the last number of years, and they perform two functions. They monitor general rule of law performance in the member states, and they also make recommendations in regard to how the rule of law, the general rule of law principles can be improved. The focus is on various aspects of the rule of law, judicial systems, the anti-corruption frameworks in various countries, media pluralism, and whether there are sufficient institutional checks and balances. There's been a slightly new focus regarding the interconnection between the rule of law, legal stability, and the single market or economic stability. And it's been recognised, and it must be recognised in a union such as the European Union, that a stable and predictable legal system and a stable and predictable country where the rule of law sounds must improve and protect economic stability, and that has been part of the thinking of this project. The project is part of the future proofing of Europe, which is supported by the Irish Department of Foreign Affairs, and that we thank them. The IIEA thanks them for that. Just very quick housekeeping here. The format is that the session is intended to last for an hour. There will be two persons who will present each for about 10 minutes, an overview of the report, and then we'll have a question and answers element of the webinar, which I really want people to get involved in. 2 or 3 things about that. You can post your questions on the window on your laptop or your computer. You should identify yourself and identify your affiliation. I should say the session is being recorded and the question and answer session will be recorded. So if you don't want to be recorded, you need to tell us. And if you don't want to be identified, you need to tell us, because the default system is that everything that is said here is on the record. So without much more ado, I move to the two speakers. Both speakers work for DG Justice, which is the Commission Justice and Consumer Unit. Both are long-term workers there, and both were involved in the processing and drafting of this document. They are the head of the relevant unit, who is Florian Geyer. Please excuse my French, I think. And Nicolaas is the second presenter. Both are lawyers. And both will perform slightly different function here. Florian will do a general overview, and then Nicolaas will identify the various elements that gave rise to concern or that were points of discussion in the report. So Florian has been working for the Commission for more than 15 years, and he's been in various DG Justice and its various configurations over the last number of years. He was a research fellow in Brussels, and he was also a member of the staff in Trier, Germany, in the public law section of that university. So, Florian, I'll pass over to you, because it's a very short webinar. I don't want to spend any more time discussing your illustrious career, because we want to hear what you have to say. Thank you.
Thank you, Judge Baker. We appreciate being here today to be able to speak to our audience in Ireland, and also those connecting from various places around Europe or the wider world. It's a public webinar, so we are excited to have the honor to be able to speak in the framework of the IIEA, in particular as also our new Justice Commissioner, Commissioner McGrath, hails from Ireland, and it's a big honor for us to be working with him. Commissioner McGrath was at the IIEA recently, gave an important speech, and we are excited to be able to continue the work on the rule of law that we have been building now over many years under his political leadership. The webinar today comes at a very important moment in time. Actually, some people might say it's the middle of summer, and who is still interested in following any kind of, like political debates, be it nationally and even less so at European Union level. But indeed, it has been a very busy July, in particular for those interested in the rule of law. We have on the 1st of July issued our 13th Justice Scoreboard, which is one of the instruments that we have been developing for many years now, and which is, mapping the independence, efficiency, and the quality of the justice systems across the European Union. It is an instrument that we value very much. It is not as much in the focus of political attention, not as much as the rule of law report, but it is indeed the fact base for the rule of law report in many instances. So the Justice Scoreboard on the 1st of July, followed a week later by the 2025 rule of law report. On the same day, the Council adopted the European, country-specific recommendations under the European semester. For those of us who follow closely this policy area, they know that these European semester recommendations also go into the areas of justice, of anti-corruption, and in fact, elements which are relevant for the rule of law. So at the same time, the Council adopted these country-specific recommendations. And just yesterday, I think the newspaper articles across Europe were full about this. The proposals on the new financial framework, the multi-annual financial framework, was the first package, the first part of that package was adopted yesterday after long hours. And these proposals live up or bring the concrete expression that many of us have been waiting for of President von der Leyen's announcement last year of creating a closer link between the budget, EU budget, financial support, and the recommendations of the rule of law report, as well as a renewed commitment to ensure that in the distribution of funds, in the use of funds, the rule of law is a must, complementing, reaffirming also the principles that were fixed in the conditionality regulation. So these proposals are now on the table since yesterday, and it will be, of course, these are Commission proposals. They will run for 2 years negotiations, but I think this is a very important moment to gather and come together now and in the coming month to see all of these elements together. Now, today's presentation, and I will start, is on the rule of law report. So one part of the different elements that I just outlined before. I will, as Judge Baker explained, give a bit of a general part, give back to the judge, and then Nicolaas will complement on some details. So on the 8th of July, we published the 2025 Rule of Law Report. In a world where democratic systems and fundamental rights are increasingly under threat, upholding the rule of law has become ever more important. And the Rule of Law Report is one of our main tools for monitoring the state of the rule of law across the Union. Every year, the report takes stock of the rule of law situation in all member states and the EU as a whole, in an objective manner that ensures equal treatment among the member states. It presents a clear picture of significant national developments, both positive and negative, based on a transparent and objective methodology. Since it was first introduced 6 years ago, the report has become an essential reference point for debates and a compass for national reforms. Its preventive nature has helped to identify risks, assist member states to take preventive action, and develop possible solutions with targeted support at an early stage. The report has evolved over the years. With every annual edition, the Commission has deepened its assessment and made it more impact and meaningful. In 2022, we added recommendations addressed to each member state individually. That was just 2 years after we initiated this process. We already came with the recommendations. And since 2024, we also added a geographical expansion of the scope, and we include now 4 enlargement countries: Albania, Montenegro, North Macedonia, and Serbia, allowing them to participate in the rule of law cycle on an equal footing with EU member states. This corresponds to the logic of gradual integration that we pursue with enlargement countries in the area of the single market. Now this year, and as announced by the President in her political guidelines, the key novelty is a stronger focus on the single market dimension, as Judge Baker already mentioned in the opening introduction. To fully appreciate the value of these reports, we need to go back to the basics. Why is the rule of law so important? The rule of law provides a stable, rules-based environment guaranteed by independent courts and institutions. It ensures that contracts can be enforced across borders, that companies competing for procurement contracts are not hampered by corrupt practices, and that, for instance, state advertising is distributed among media companies in a transparent and fair manner. In short, it gives certainty to businesses, confidence to investors, and reassures citizens. In adding the single market dimension, we have built on the work in previous years. We are now further deepening our assessment and expanding it to other core issues. The country chapters report on, for example, the specialization of courts and judges to handle commercial cases, measures to prevent corruption in public procurement, transparent funding for the media, and the stable regulatory environment necessary for businesses to operate in a predictable environment. We will work with member states to help them address these issues, including through dialogue and good practices. All this strengthens our single market and our competitiveness. We would like to highlight two other particular elements from the report. As is the case every year, the Rule of Law report also includes a dedicated section on media pluralism and media freedom, a priority of this commission and of Commissioner McGrath, who has been also tasked directly to ensure the implementation of the new key law that will come into force actually and become applicable in 3 weeks' time on the 8th of August. And that is the European Media Freedom Act, which is a crucially important piece of hard EU law that will become enforceable at the time, and which member states had the time to implement, and which will give the Commission and the EU the tools to ensure many aspects of what we report on in the Rule of Law report and have so far formulated as recommendations as hard enforceable law. This EMFA, as it's called, supports the internal market for media services while also protecting media freedom and editorial independence. And the monitoring of the situation of media in our member states that we conduct in the framework of the Rule of Law report is a valuable basis for the implementation of EMFA. Finally, last but not least, the report continues to assess the situation of civil society organizations and national human rights institutions. They are an essential element of member states' systems of checks and balances, and in some member states, efforts are ongoing to strengthen these institutions, while in other member states, we continue to see old and new challenges. Again, one of the messages that we want to pass also when presenting the Rule of Law report is to make clear that it is one part of a wider endeavor that are done at the EU level, at the Commission's level, to address these aspects that we are covering. And here, in particular, when we come to the civil society framework, we also would like to highlight that later in the year, the Commission intends to propose a full-blown civil society strategy for which the public consultation is currently ongoing. And together with the European Democracy Shield, another milestone deliverable that we want to present later in the year, this strategy will be an essential part of our broader efforts to bolster our democratic resilience across the Union. So it's not just the Rule of Law report. Very often the critic is, nice, you have recommendations, how do we enforce them? Or the Rule of Law report does not cover civil society deeply enough, it doesn't cover democracy, why are you not doing anything? So we try to explain up front that this is not the only important tool that we have in policy area in the wider field of democratic resilience across the Union. Now, the Rule of Law report remains our well-established tool for monitoring developments on the ground, providing a clear picture of where we stand and where action is needed. A core priority of this mandate will be to come forward with concrete measures that directly address our concerns. And these are not just technical or academic issues. They go to the very heart of what being European means. Whether they realize it or not, the rule of law issues have a daily impact on the life of citizens and businesses across Europe and on the resilience of our democracies. The rule of law and democracy are inseparable. They are two sides of the same coin. And the Commissioner McGrath, is committed to upholding both to protect the very foundations of our union. Before now, Nicolaas will come in to go a bit deeper into the concrete findings, apart from the very general words that I have been given. I just wanted to also underline and give some of the figures that explain a bit why it takes a year for the Commission to come out every year with this, and the immense resources that go into producing this report. So as a response to the stakeholder contribution that we asked last year, we have received 270 contributions this year. This is a stable number that we rely on for providing and preparing the reports, the 27 country chapters, the 4 enlargement countries. In total, they run over 800 pages of documentation and Commission assessment. We held over 650 meetings across the 27 member states and the 4 concerned enlargement countries. And if you break down these meetings into how many national authorities, ministries, courts, judges, independent bodies, civil society organizations, other stakeholders we met, this is a figure of over 980 participants in the overall process only for the 2025 report. I stop here, Judge Baker. Thank you for your attention, and Nicolaas will take over.
In fact, that you positioned the sorry, I was being unmuted. I think it's important that you position this within the wider sphere, within the wider sphere of the Democracy Shield and the Future Proofing Europe project. And I think it's important that the audience sees that and sees this. As I look at it, it seems to me that what this does is it provides the reference point for a debate. It's the evidence that allows a debate to be both analytical and to rely on evidence. And that, of course, is a key to a proper debate and a proper analysis. And also, I think, the way in which there are concrete measures recommended in the Rule of Law report. Again, that's a key, not to make this more than a talking shop, to make it something that can move on. And I think later in the debate we'll discuss, or somebody will ask you where you have your teeth, how you do in fact propose moving along. But before we do that, I'm going to move on to Nicolaas. Nicolaas Bell is also a lawyer. And he has been working with the European Commission for 20 years now in DG Justice as well. Before working with the Commission, he worked in private law in the Netherlands, and he's the deputy head of the DG Justice and responsible for this Rule of Law project. So, Nicolaas, again, as with Florian, I'm not going to spend time speaking of your illustrious career because we want to hear what you have to say. Thank you.
Thank you, Judge Baker. So, like in the previous years, the Rule of Law report of this year covers 4 key areas: the justice system, the anti-corruption framework, media pluralism and media freedom, and other institutional issues related to checks and balances. Now, I would like to highlight some of the findings of this year's report, focusing on the first pillar, the justice system, and the 4th pillar on the checks and balances. Justice systems in member states, they must be efficient, well-functioning, and fully independent in order to be able to provide effective judicial protection to citizens and businesses, and to effectively apply and enforce EU and national law. And we've seen that in the last year, several member states have advanced on justice reforms. steps are being taken in some member states to strengthen the independence of their Council for the Judiciary, or to introduce further safeguards in the process of judicial appointments. For example, in Spain, a structured dialogue held last year with the Commission has now led to a renewal of the Council for the Judiciary, which was long overdue, and steps have been taken towards adapting the appointment procedure of its judges' members with a view to taking into account European standards. In Ireland, the newly established Judicial Appointments Commission has started its work, a commission that was established to reduce political influence in the appointment and promotion of judges. We also see at the same time concerns as regards judicial independence in certain cases. For example, in Hungary, the report notes that within the judiciary, undue pressure on some judges continues. And in Poland, we are waiting for a ruling of the Court of Justice on the Constitutional Tribunal and whether it meets the requirements of an independent court. Turning to the resources of the justice system, which is something that is monitored in the report as well, we see that in many member states there is a strain on resources, which obviously can impact on the quality and the efficiency of justice. Some member states face long-standing challenges as regards the efficiency of their justice system. We mention Greece, Italy, and Malta as some dire examples. But also in Ireland, there are concerns about the length of proceedings, which need to be addressed. At the same time, we see, for example, in some member states that initiatives to digitalize the justice system are advancing, and this can, of course, enhance efficiency in the justice system. Judicial salaries is something we look at. They are being increased in some member states. For example, in Germany, steps have been taken in that respect. And obviously, the level of remuneration of judges may impact the attractiveness of the judicial profession. And we see that in some member states, there are challenges to attract new judges to the judiciary. Finally, as regards the justice system, a word on cost of litigation and access to legal aid, both of key importance in order to ensure effective access to justice. And we see, for example, that in some member states, steps are being taken to reduce the cost of litigation, also in Ireland, following a Commission recommendation to that extent. And the Commission will continue to closely monitor the effectiveness of national justice systems and the access to justice in all member states, also in the context of its annual EU Justice Scoreboard. Now let me turn to the fourth pillar of the report on checks and balances. A well-functioning system of institutional checks and balance is at the core of the rule of law. It is important that power exercised by one state authority is always subject to the scrutiny of others. And we see that in a number of member states, reforms are underway to strengthen the system of checks and balances, which is a good thing. And this includes, for example, initiatives to structurally better involve stakeholders in the legislative process and thereby improve the quality of legislation. Unstable laws, fast-changing laws, sometimes drafted without asking for input to stakeholders, are still a concern in some member states, and this can give rise to legal uncertainty and affect businesses and citizens alike. We note, for example, in Slovakia and also in Hungary, the frequent use of fast-track or emergency procedures and practices when drafting legislation of bypassing stakeholders in the process. A word on civil society organizations, which also fulfill a crucial role in the system of checks and balances in member states. They are the watchdogs flagging rule of law breaches where they emerge, and ensuring that those in power remain accountable. In the majority of member states, there is a supportive framework for civil society, as also reported in this year's report. But in some member states, obstacles remain, for example, related to funding of civil society organizations or registration requirements, which are unduly harsh. We see that in Ireland, steps are being taken to look into some legal obstacles to accessing funding by civil society organization, also following a commission recommendation to do so. In some member states, we see civil society facing serious challenges, being made subject to excessive financial restrictions or controls and inadequate protection. Hungary and Slovakia are some of the prime examples in that respect. Maybe a few words on the single market dimension. As Florian already said, an effective justice system, effective fight against corruption, good governance, legal certainty, sound lawmaking, all have a significant economic impact, shaping the business environment in member states. And this year's report looks more into detail into issues like specialization of courts to handle commercial cases, which are particularly relevant for the business community. Also look into measures to prevent corruption in public procurement, transparency in funding of media companies through state advertising. We see distortions in some member states in that respect. And as we discussed already, the stability of the regulatory environment, which is important for businesses to operate under predictable conditions. Also, interestingly, this year, for the first time, the report looks into the effective functioning of some key regulatory authorities for the single market, notably the functioning and independence of public procurement authorities and national competition authorities. And the level of perceived protection of investments through the lens of companies is also being monitored through surveys reflected in the report. And this single market dimension will certainly be further deepened in next year's report. Now, what is the next step? The Commission invites member states to address the challenges identified in the report, and notably those referred to in the recommendations addressed to member states, and the Commission stands ready to support member states in their efforts. And of course, dialogue always comes first, but dialogue must lead to results. And the Commission will always be ready in critical situations to use other tools of its rule of law toolbox, including infringement proceedings, but also budgetary instruments to ensure that the rule of law is upheld across our union. And just to conclude, this report is an important monitoring tool, but it is part of a broader endeavor to protect and promote the rule of law. We are waiting later this year for the European Democracy Shield. An EU civil society strategy will be launched. We have the European Media Freedom Act, which will have to be implemented in August by member states. We are negotiating an anti-corruption package, which provides important proposals for legislation to combat corruption in the European Union. And as Florian said, of course, yesterday, the Commission adopted its proposals for the next multi-annual financial framework, which also includes a range of provisions to ensure respect for the principles of the rule of law and fundamental rights in the implementation of the budget. I would like to stop here and turn over back to you, Judge Baker.
And Nicolaas, I for one would have listened to you for much longer, but in a session as short as this, I suppose we have to give some time to questions. But the points you make show that this is not just a talking shop. The analysis is very deep and it's very detailed, and this is important. Just to illustrate very briefly one or two matters that have arisen in Ireland, we have changed the method of appointment of judges. Taken it out of what I think was generally regarded as a political sphere. And the first new judges appointed under the new system were appointed last week, and some more this week. So that is a positive, concrete result, I think, of engagement between the Irish government, the Irish judiciary, and DG Justice in its various forms. I think it's also very interesting that you're concerned about the particular role of civil society. And a lot of the people who were here, the 82 people who registered to come today, would class themselves as actually being members. Some of them are retired out of public or civil service jobs, but they would class themselves as being members of civil society, conscious of the need for institutional support and conscious of the need to regulate and ensure funding. I know the Electoral Commission of Ireland is as part of its study about election funding, considering the broader question of the funding and whether there should be any restrictions on funding for civic society around elections. And that report will be published much later in the year, probably in October, November, I think. But what you say about the actual checks and balances which are there and the actual detail of the work you've done, I think will encourage people to feel that there is, in fact, much more than just talking going on here. But maybe I could ask you a question. There are some questions coming in. Maybe people would continue to add the questions into the website. But you do have tools. You have rule of law tools, as you call them. Those tools are effective, but are they not very slow? Dialogue, infringement proceedings, gentle pressure, embarrassment perhaps of countries, restrictions on the availability of funding. Are they too slow, or is that the way it has to be? Hard question. Both of you can answer, not together.
Well, I think that is, of course, it's one of the key questions. The tools and the questions are: do we have enough tools, and indeed are they in fact effective enough? And yes, I think it's a learning process also. I think if you look back at the history on the rule of law at European Union level 15 years ago, you would not even have a unit like we have now that would be tasked with looking into these aspects. Rule of law was something that happened in the outside world, the enlargement countries, the Copenhagen criteria. There you needed to fulfill the benchmarks, then you get the entry ticket, you enter the union, and everything is fantastic. Nobody will ever look again into your national systems, the rule of law, fundamental rights, until it would have reached a level of Article 7, which nobody ever wanted to activate. Of course, history has proven us wrong in this assumption, and the need was seen to develop these tools because indeed the dynamism in our member states has proven that need. So the tools, apart from the classical ones of infringement proceedings and the Article 7 treaty-based, leading to potential suspension of voting rights, has grown. I think also we have learned in the last years to make it has grown in terms of new tools that have been added, like the conditionality regulation, also the funding via the RRF, the Recovery and Resilience Facility, and even the rule of law report as a basis for having a discussion that is informed, that cannot be denied based on the argument system. You're just some unelected bureaucrats in Brussels, with your pre-perceived concepts of degenerated Western liberalism, and you don't know how our system works. So since 6 years, I think we go very deeply into this to showcase that there is an understanding of the national systems that then allows also the political decision makers to have an informed discussion in the council, in the parliament, at national level. And we have also learned to use the existing tools faster where needed. I think the infringement procedures, we have learned to request interim measures when we felt they are needed, accelerated procedures, requests for financial sanctions for the breach of interim measures. So I think the last mandate has shown that we have done things that have not been done before, faced with an objective need to act quickly. Of course, we should and can act in other areas also more, but I would also like, and I always make this point, we should not underestimate the dialogue dimension that you mentioned, because sometimes the dialogue can actually achieve faster results than the formal tools. As soon as you enter into a formal process, you basically are on a track, you are on one train. So, and once you position against the member state to say, see you in court, that member state will of course say, all right, so let's see. And that takes then the time it takes for the court and the exchange of, this is a formal legal proceeding. I think if you look at some of the recent events, for instance, in Slovakia, where we did not launch formal procedures, but in fact, we managed through dialogue to prevent some of the more dangerous developments that we saw. For instance, an amendment to the whistleblowing law that would have basically, taken away the whistleblowing protection of even recognized whistleblowers who were crucial in unraveling some of the corruption scandals of the past. This was not pursued after it was made clear by the Commission that there would be strong violations of the EU whistleblowing directive. The Protection of Financial Interests Directive, we, together with convinced the Slovak authorities to change their law 3 times last year to bring it back in line with the PIF, Protection of the Financial Interests Directive, without any formal procedure having been launched. And this happened within, let's say, 10 months. No court judgment would come so quickly.
No, never.
And even even in Hungary, where the criticism is the strongest that we are not acting fast enough, I think we managed to convince that one of the very controversial laws in the civil society framework, a draft law on transparency in public life, which would have made the remaining civil society framework in Hungary essentially obsolete, has not been moved forward. It's postponed to the autumn. Who knows if it will come back? It is something we need to remain vigilant, but it was made clear that also through the actions from many international actors, but including the Commission, led to a rethinking, at least a temporary, reprieve, that this law has not been entered into force. It was supposed to enter into force or be voted in on 4th of June, and it was postponed to the autumn. So this is where dialogue and pre-legal action, pre-actual teeth formality has shown results.
Yes, and I suppose you could say that dialogue, as opposed to a battle, a two-sided battle, is part of the fundamental philosophy underlying the way in which the Union was established and the reason it was established, and is reflected indeed in the way Irish law now thinks of the importance of alternative dispute resolution and how people get encouraged, if that's probably too mild a word, to engage in mediation and other forms of ADR rather than going to the longer process, which does not always result in the best answer. So, Nicolaas, do you want to add anything there, or can I put the first question from the floor to you?
Yeah. No, I just want to add that I also think that dialogue is underrated in the minds of many EU observers. And I believe in the strength of peer pressure and embarrassment, if you wish, very much. At the same time, it is important that we have learned to use our tools effectively in critical situations. And so this combination will always be necessary, but I still believe dialogue always comes first.
and produces a more nuanced answer that can satisfy everybody at one level. Can I put the first question to you from actually a member of the IIEA, Liam Roach, who asks, when can we expect the 28th regime for companies to be implemented? Now, for those, including myself, who know very little about this, the 28th regime is in progress. The discussions are in progress, and a report is expected, I think, at the end of the summer, regarding a voluntary code, Europe-wide code in the form of company and contract commercial laws, and that's so. How far are we in all of this?
All right. So that is something, it's very interesting that you bring this up in the context of the rule of law discussion. So it
is actually, yeah, very interesting question.
Exactly. It is something that the 28th, normally, when we speak in the rule of law report, the 28th chapter is the missing one that many observers from both spectrums, of observers expect. The 28th chapter is the one, when do we look actually at the rule of law compliance of the EU institutions themselves? But the 28th regime, in contrast, is, the announcement by President von der Leyen on this new, company law setting of how to structure a company, how to ingrain it. There, the work is ongoing. So that is not something that we do in our unit. It's in a related directorate. I would be lying if I would tell you any details about the progress, but I know that is something that is very much driven forward, because it's one of the key initiatives that President von der Leyen announced. I'm pretty sure the plans are that this will still come also in 2025. Must have been in the work program, and I hope we will be able to see that proposed in the autumn as well.
Yes, Nicolaas,
I
know. Well, I mean, it's probably that's a question that I deliberately put to you, because I think a lot of people in the audience would be interested to know just where it is. It's clearly. It will, if it comes into operation, or if anything along those lines come into operation, it would be a voluntary code, but it would facilitate some smaller businesses certainly doing business in the European context, and some harmonisation in some of the private law is probably desirable in that respect. Can I ask Nicolaas a much harder question concerning the Digital Services Act? And this is a question that's come in from Thomas O'Reilly from ADF International. He wants to know whether there is a risk of politicised national enforcers, and how the rule of law thinking will be applied to that. Now, his example is this one, and I'll put it to you. Dublin, Ireland, potentially siding with American platforms over EU commitments. So he also says, anything else about the Digital Services Act, and to clarify where we are with that, would be welcomed. It's a big topic, Nicolaas, so I don't expect you to do much more than give us some guidance as to where it's going.
Well, what I can say is that it is in a way linked to the work we are doing in the rule of law report, with the single market dimension that we are now starting to develop in the report. We are looking this year for the first time beyond the justice system. We're looking at the functioning and independence of key regulatory authorities, essential for the functioning of the internal market. We're looking at, in particular, at public procurement bodies where they exist, and national competition authorities. And of course, it is important that these regulatory authorities are independent and can take their decisions impartially to ensure a level playing field in the single market. And there is also EU legislation, EU acquis, defining how these authorities should function. So our thinking is not starting from scratch. Of course, the vast thinking and case law that has been developed on judicial independence serves as a source of inspiration. But it is clear that the effective functioning and independence of such key regulatory bodies is very, very important.
It is. There's another question actually that comes in that's related to it from a Dermot O'Riordan, who says, does your work and does the rule of law work generally speak to the tension, which I think must be recognised as existing, between the Digital Services Act and unfettered freedom of expression, which is a constitutional value in Ireland and indeed in convention countries generally. So, are you conscious of this? Do you think the discourse is able to handle the complexity of that tension?
Well, it is a very important issue that needs to where, let's say, the fine line will need to be defined and protected. It is, of course, also related to the Charter of Fundamental Rights.
Yes.
And all the thinking that has gone into that concept over the years, the case law of the European Court of Human Rights. I think what you mentioned, and also more broadly, the European Media Freedom Act.
Yes,
they are
the other part of it, of course.
Yeah, they are very, let's say, complementary to what we are doing in the Rule of Law report. In fact, you could even say that they are the follow-up on our earlier findings in the Rule of Law report on the media pillar of the report, where we have identified in some member states structural deficiencies in the regulatory landscape of the media that has now found its way in legislation that can also be enforced. But it remains a delicate
it remains a delicate topic, and it remains a topic that needs a lot of discussion and a lot of, I suppose, awareness, public awareness as to the complexity of the debate. It's an issue that arises obviously in the Electoral Commission, and it's part of our thinking, because part of the Electoral Commission's thinking is we must educate people to understand the systems and to speak about the systems and to avail of freedom of expression, and in the meantime to understand how digital advertising works. And that's not easy in any country, and certainly requires a lot of thinking. Can I go back to a different question here, which it sounds very parochial, but it's not really. Our Commissioner McGrath is in fact the Commissioner for Justice, and for not quite for justice. His role, I'm afraid I can't say, but it's a subset of the rule of law project, and he is in fact, I think, the key mover in the Democracy Shield work. What role specifically can Ireland play in its presidency next year? Because we are seen as, I think, a voice of reason, and a voice where democracy is still regarded generally by the people as of some value. And I don't know if you, Nicolaas, and Florian know this, but a recent survey conducted for the Electoral Commission suggested that there's huge confidence in the electoral system in Ireland. Huge confidence, 70-80% across the board. So perhaps we are an important voice, but perhaps you tell us what voice and what role you see we could specifically perform next year when we take on the EU presidency. So some sticks and some carrots here, please.
No, I think it's always, like the role of the presidencies, they're crucial. They play. They are the drivers, as you say. They fix the agendas of the council. They drive forward also in our areas the debates, for instance, on the Article 7 procedure. They decide what type of level they want to have. Like, is it just a hearing of the member state concerned? Is it a hearing, or is it just a state of play? Do we want to increase with our ambitions and sharpen the dialogue on the rule of law in the country chapters? Or very often each presidency also has developed now the tradition of organizing a conference on the rule of law, bringing together academia, stakeholders, also to think forward of what are the important topics, what lies ahead. In the Justice Council, they chose the topic, a rule of law topic that is being debated among justice ministers on the rule of law. And here I think, in the end, it very often comes then down to what are the challenges of the time that the respective presidencies are facing. And here, of course, we will be able to look ahead and consider, where will we stand in 1 year's time? We will most likely have made, a very strong leap forward on the negotiations of the MFF. So I think our Commissioner McGrath, as former finance minister on the one hand and now justice commissioner on the other hand, in charge of rule of law and democracy, will certainly have very good conversations with his Irish colleagues, in the presidency, to bring together these very important dimensions. It is also very likely that at the time of the Irish presidency, the question of enlargement will be even stronger in focus, and we might, be ahead of a new enlargement round or in the last steps of closing chapters. Again, I think the Irish experience, having joined the union, and having this voice, as you say, this voice of reason also, will be very important in ensuring that the enlargement process is fair. And at the same time strict, and that the benchmarks are being kept. One important development that will be ongoing, maybe already started, but maybe concluded under the Irish presidency, will also be the question of the. It's a reflection that was tasked by the European Council, so by the EU leaders, is to ask ourselves: are we actually ready for enlargement? Is our institutional setup the right one? Can we live with unanimity decisions in the foreign policy field forever? Will we be able to function if we are, for instance, a union of 36? So these are very forward and future-looking questions about the future of the union, and that is where the Irish Foreign Ministry also has the webinar topic on. So the future-proofing of the union is a very important one, and it could become very relevant during the Irish presidency. And of course, Ireland, on the rule of law, is among those member states which have always been, those who ask for reform, who ask for more, who, is among those which, move forward. I don't want to use, like the term, but there is, Ireland is a very important member, in this group of member states that is a good ally for EU values and function based on the rule of law.
And it's a particularly dangerous time in the history of the world for an Irish minister to take the role. And I must apologise to Minister McGrath. Thank you, Heather. He is the Commissioner for Democracy, Justice, the Rule of Law and Consumer Protection. It's what we call a big mouthful. Nicolaas, do you want to say anything about how you see Ireland's role, Ireland's positive, I hope, role? But as I say, you can use carrots and sticks here.
No, I think it's interesting also to see in the rule of law report that Ireland is among the member states where the perceived level of judicial independence is the highest. So
yes, that's correct.
A number of Scandinavian countries, also the Netherlands and Luxembourg, they are in the, let's say, in the upper league of perceived judicial independence, and that also makes clear, how judicial independence is valued in Ireland and how it is seen as being a very important thing. And obviously, this thinking also applies very much to the construction of the European Union. So Ireland is very well placed, also with its know-how and legal tradition to play a very important role on the values and rule of law front, where there still is a lot of work to be done. And it is structural work, and it is work that is absolutely necessary for the proper functioning of our European Union.
Yeah, and listeners mightn't be aware, actually, that the Irish Supreme Court is the oldest continuous Supreme Court in Europe. In fact, leaving aside the United States, it's the oldest continuous Supreme Court in the Western world. So, and we had a celebration of that last year, and we are conscious of the fact that Irish people do have a huge level of confidence in the judicial system. Can I ask you, there's a very specific question that comes in from Mami Nazema Najoy, and I hope I've pronounced her name correctly, whether the EU would support a transnational anti-corruption court. Now, that's a big question.
Wow, exactly. I looked at the questions that we are receiving today.
I wasn't promising you a rose garden here.
No. I think on the anti-corruption, as also Nicolaas mentioned in his part of the intervention, I think what we are currently doing is try to negotiate inside the union a new EU anti-corruption harmonized law, criminal law, tackling preventive elements and repressive sides, and this is actually one of the negotiations that also Commissioner McGrath is tasked to conclude. We had recently a trilogue, so the intended end of the negotiations between the Parliament, the Council, and the Commission, where we did not make as much progress as we wanted to, also due to the opposition of some normally very supportive member states in this area. And I do carrots and sticks because it's the member state that I come from, where Germany played in my view, not a very positive role in preventing an agreement for various reasons, more of dogmatic nature of the criminal law system. So there we need to make more work. So I think the first priority would be to make sure that inside the union we have, strong enough rules that would need to be implemented. A second objective is the GRECO, the Council of Europe's body.
Yes, GRECO is very important in this.
There, a long-standing question is whether the EU should or could join GRECO as a member on its own. So not only through its member states, but the EU as such. So I think that would also be a first step. But then, questions on the international cooperation side on strengthening anti-corruption, including the questions on the supranational international body looking into this, is certainly something that is part of the wider thinking. But I cannot tell you now whether this would be, whether there is an established line, whether we would support it. As I said, we would first need to make those steps internally and bring our house in order, if you want to put it like that.
Yes, I have one more question. And of course, the other thing is, but if you have harmonized law, then you have the engagement of the court in Luxembourg on interpretation. So that's important. I have one more question, and I'm going to put it in from Attractive Ren. She asks about civil society participants who consistently voice concerns about the erosion of the rule of law and access to justice, but don't see their concerns reflected in the report of their individual countries. She says Ireland's country report doesn't actually mention the amount of concern expressed by civic society regarding the erosion of the rule of law in Ireland. So that's again a big question. As I said, I never promised you easy questions. Nicolaas, do you want to look at that?
Well, I think we're very sensitive to the feedback we are receiving on the report. So we are getting feedback from all member states, from the government, from organs in the justice system, but also from stakeholders. And it is very important for us to get this feedback. I think we are striving for a report which is relatively short, if you wish. Maybe some consider the language a little bit dry. What we intend to produce is a document that can serve as a basis for discussion in different fora among member states, with other European institutions, but also with national stakeholders, the judiciary, and civil society organizations. We're always trying to improve our reporting, but okay, there are also limits to how deep we can go. We try to be fair and objective and as comprehensive as we can be in the number of pages that is allotted to us. And we hope that the report can serve as a useful basis for discussion. And that includes criticism, if you wish, of those stakeholders who think that their input should have received a more prominent place.
Well, that question I take it will feed into your thinking for that as regards the response to the report. So perhaps the questions will be passed on to you in any event.
Maybe let me just add also on this point, because we are actually very aware of the also the views of the Irish civil society. But I think it's also important to see that in the context of the overall chapters, and our intention to find a comparable and balanced also reporting, not only within the member state that we look at, but also for all the 27. And in fact, we have a recommendation on civil society in the Irish chapter. We assess that, and this is about the legal obstacles related to access to funding for civil society organizations, and indeed as part of the Electoral Act, also the Reform Act. So, and we recognize there that there are views which are expressing disappointment about the progress made, and concerns about the impact of legal provisions under the Electoral Act to receive donations above a certain threshold. So not every member state has a recommendation on the civil society framework. This also has to be recognized. And yes, we cannot reproduce everything that we receive, not only due to length, but also due to the fact that it's the Commission's assessment, and we need to balance all the views that we hear in a certain country. And indeed, it is important that we get that balance right. So we understand that it is sometimes frustrating for participants not to see their input reflected in the way that they thought it should be. But that is due to, it's not that it has been ignored or it would not have been seen, discussed. We also discuss in the country visits, but simply because in the putting together the overall balanced approach, it is the Commission's view on the situation, and it's not reproducing one-on-one everything that we receive.
Well, that question can in fact be passed on to the Electoral Commission for its review on the 1997 Act, and which might then come back to you next year for your next report.
Indeed.
I'm told that the hour is up. I thank you both for your contribution. I think we would have probably been able to go for another 20 minutes or half an hour, but this is the promise that it's an hour's webinar, and that's a promise I'm going to keep. Thank you both for your contributions. thank the audience for listening, and thank those who asked questions in the chat for their questions and for keeping the event going. Thank you all very much, and thank the IIEA for organising this.